Hello and welcome to ProfDale's Property Video number 20. I'm your host, Dale Whitman. In this video, we're going to wind up our discussion of concurrent ownership or co-tenancy by talking about two specific areas. First, community property, a form of co-ownership that exists in about 8 states, and homestead rights. So let's begin with community property. The map and the list show the 8 states that recognize the concept of community property. You'll notice that all of them are in the south or southwestern or Pacific coast areas of the United States. All of them have some connection with either the French or, in most cases, the Spanish civil law. And indeed, that's the origin of community property. It comes from the civil law concepts that are followed in Europe. Now, there are 2 additional states that are not technically community property states. They're Wisconsin and Alaska, and they have marital property statutes that produce results that are very similar to community property. Now, it's always a little risky to make general statements about community property because all of the states that recognize it are different and vary from one another. Nevertheless, there are some things we can say that apply to most or all of the states. 1, community property applies only to married couples. Single individuals simply can't own community property. Second, community property is mutually exclusive with tenancy by the entirety. In other words, no state has both community property and tenancy by the entirety. They are simply 2 different forms of marital property ownership, and they are exclusive of one another. Third, spouses can own both separate property and community property, and it's quite common in a marriage to see a husband having separate property, a wife having separate property, and the 2 of them together owning community property as well. Separate property consists of property that is owned by one spouse prior to the marriage and is brought into the marriage by that spouse. It's also property that's acquired after the marriage by gift or by inheritance. And finally, personal injury awards to one individual spouse are considered separate property. On the other hand, community property consists of all of the money that is earned during the marriage by either spouse and all of the property that is bought by such earnings during the marriage as well. In community property, each spouse owns half of the community property. When one of the spouses dies, the other simply continues to own his or her half. However, the decedent's half, the half of the person who died, passes by will or by the intestacy of that person who has died. Now, that may very well pass to the surviving spouse, or it may not, depending on whether there's a will, and if there is no will, depending on the intestate succession statute of the particular state. In a divorce, there are 2 different views about what happens to the property depending on the state. In most of the community property states, the community property is simply split equally between the 2 spouses. On the other hand, a few of the community property states follow a principle of equitable distribution, which means that a court can look at the circumstances of the individual spouses and can decide that one of them should get more of the community property than the other receives. Notice that property that is held by spouses may and often is mixed. For example, a wife might own a house with a mortgage on it before her marriage. After marriage, both spouses earn income and they make mortgage payments together. Well, mortgage payments made by either or both of them are community property payments. So the result is that the house is partly considered separate property. That's the equity that the wife brought into the marriage when she got married and already owned the house. And at the same time, the remainder of the interest in the house will be considered community property. So it can be quite complicated. Management and control of community property are vested in each spouse equally, so both of them have a say in what happens to it. A conveyance of community property real estate by one spouse alone without the other's consent is simply void in most community property states. So with real estate, it requires the joinder of both spouses. Both have to sign the deed in order to sell community property. Now, because many times the spouses have lived in both community property and separate or common law property states, they may have both substantial community property and substantial separate property. In these days, when many couples are mobile, it's almost always true that they'll have both some community property and some separate property. The courts in the common law states generally recognize the principles of community property, and they'll recognize that if the property was community where it was acquired, then it remains community property even though the spouses have moved to a separate property state. In a divorce, that means the court has got to trace the assets from their origin to the present day, and it can get extremely complicated. That's one of the reasons that in community property states in particular, divorces are usually handled with property settlement agreements rather than with litigation, because the litigation is so complex. Now we're going to change and talk about homestead rights. It turns out that the word homestead is incredibly elusive. It has many meanings. We're going to talk about the four most common meanings in this part of the video. First, homestead was a way of acquiring land from the federal government. This is probably the meaning of homestead that's most familiar to most people. The Homestead Act of 1862 introduced the concept of acquiring land from the federal government by means of homesteading it. There were a number of subsequent acts as well. The applicants had to file an application, improve the land, for example, to build a cabin there. They had to reside there for 5 years, and then at the conclusion of their residence for 5 years, they had to file an application for a federal patent, which was like a deed conveying title to the land to them. In most cases, the applicant was entitled to 160 acres of land in this way. Now, the Homestead Acts were ended in the lower United States in 1976, and then 10 years later in Alaska in 1986. So it's no longer possible to acquire land by homestead from the federal government. The second meaning of the word homestead is that it's an exemption from the claims of creditors. And what we mean by an exemption is that to the extent of the homestead exemption, the creditors simply cannot reach the homestead property. They can't attach it, they can't execute on it, they can't have it sold to pay debts. Now, it usually applies only to a family home, which means that the owner usually has to either be married or have dependents living in the home. It's not necessary to file or declare this kind of homestead. It's an automatic exemption just by virtue of the property being a homestead. It may be limited in size. In a number of states, it's a fairly small area, such as a half acre or 1 acre in size. In addition, most of the states limit the homestead exemption in amount, such as to $50,000 of equity in the property. There are, however, a few states that have an unlimited homestead exemption. Florida and Texas are quite well known for having unlimited exemptions, which makes it quite difficult in many cases for creditors to collect their debts in those states. A third meaning of the word homestead is that it's a reduction in the property taxes. Once again, it usually applies only to a family home where the owner is either married or has dependents living in the home. The owner does have to file an application to be entitled to this sort of homestead property tax reduction or exemption. The exemption may be in the form of a percentage credit, such as 25%, or it may be a fixed dollar amount of reduction on the property taxes for that property. It is often limited to people who are low and moderate income taxpayers, so the wealthy may not get any benefit from the homestead reduction in property taxes. A fourth meaning of the homestead concept is that it affects the passage of title to a decedent's home when the decedent dies. Once again, it usually applies only to a family home where the owner lives there with a spouse or with dependents. It preempts the will or the intestate succession of the individual who owns the home. So instead of going by way of the will or intestate succession, the property instead passes to the surviving spouse by way of a life estate if there is a surviving spouse. If there is no surviving spouse, it'll usually pass to the children of the owner, and they get to keep the property and possess it until they reach the age of majority. The purpose of this concept, of course, is to make sure that the spouse and children of a decedent have a place to live after the decedent passes away. Well, that completes all the videos on concurrent ownership. In our next video, we'll begin with an introduction to the law of landlord and tenant. If you have questions or comments, email ProfDale01@gmail.com. Thanks for watching.